Good morning, everybody, and welcome to another edition of the PALCUS FYI webinar series. We hope that you enjoy the information that we are providing here to the community, and please share this information with friends and family, as it is open to everybody, and our goal is to share this information with as many people as possible. For today's webinars, we are going to be talking about the immigration policy update around the Provisional Unlawful Presence Waiver. This will be presented by Cynthia Russo, who is a lawyer in Newark, New Jersey, and she is also on the PALCUS Board of Directors. So thank you very much, Cynthia. And for those of you who have questions, all attendees are in listen-only mode, so you'll want to ask your question in the GoToMeeting console box. You can see it here. You just type your message, and I'll be reading out the questions to Cynthia, and she will answer them here. If you come up with additional questions after the webinar, you can always send them directly to PALCUS at palcus.org, and then Cynthia will, or someone from PALCUS will respond to your questions via email. So without further ado, I'm going to hand it over to Cynthia, and she will talk about this new update. Cynthia, go ahead.
Good morning, Angela, and good morning, listeners. Today I'll be giving information about a new procedure pertaining to a waiver with immigration applicants. It is available for undocumented immigrants who are married to United States citizens or who have United States citizen parents. It does not apply for people who are trying to use the waiver for their children. Very important to remember. Those who are married to United States citizens or who have United States citizen parents must prove extreme hardship to those qualifying relatives, either their spouse or their parents. And a little later on in the conference, we have a list of items and documents that are used to prove extreme hardship, and also explain in detail the types of hardship that immigration considers. These changes are in effect as of March 4th, 2013. We are able to file this application for the waiver. It's an I-601A. And after the waiver is approved, the applicant can decide if he's going to continue consular processing or if, in fact, he's taking another course of action. Okay. So if you are a spouse of a United States citizen or a child of United States citizen parents, you must first have an approved visa petition, which would be the first step that you file. It's an I-130 application, and once that's approved, to prove your relationship, basically that's what the I-130 does do. It proves that you are, in fact, married. It doesn't give you a benefit or an entitlement yet. That's when you have to file the waiver to pursue to get your permanent residence. So once you have this approved visa petition, and you have been in the United States unlawfully, it could be that you entered through the border without inspection, or you've overstayed a visa so that created an unlawful presence in the United States, and you are subject to 3- and 10-year bars. You would normally have to go out of the United States and apply for your visa outside at the consul and wait the time period of processing for the waiver outside. And this could be a long separation for family members, for husband and wife. So it was decided on January 3rd, 2013 of this year that if you did qualify, that you could file your waiver in the United States, and once it's approved, you would continue your consular processing. You still have to go out of the United States to receive your permanent resident status, and you still have to appear before the consulate of your country. You cannot receive your green card or your permanent resident status in the United States with this type of waiver. It's just allowing the family members to stay together and not be separated for so long And it's a great idea. It's a great idea for people who are married, have kids, have been together for a while, or they're helping their parents, and so there is extreme hardship if they were to leave and be separated from that family member for a while. It is very important to note that under who qualifies, we have unlawful presence as the third item, and it is not for people who have a fraudulent entry or a fraudulent visa or who have some criminal issues or make them inadmissible for any other reason other than unlawful presence. So it gets a little complicated, and if you are trying to do this on your own, it is really tough to do. You'll have to make sure that you know what you're doing. So I would definitely recommend consulting an immigration attorney in your area to see if you qualify. Take all of your tax returns, your children's birth certificates, your marriage documents to show you've been in the country since you last entered. Take your passports to show you had exits and entries. If you take this all to an immigration attorney who is well-versed in issues of immigration law, they will be able to tell you whether or not it's worth it to spend the money to file this waiver, because it is important to remember that it's not just the fact that you're married to a U.S. citizen or you have citizen parents. I mean, you cannot just file this waiver. You must be able to prove extreme hardship. So if you're going to pay the fee for this application, which it's $585 plus $85 for fingerprints, you want to make sure that you're not just filing it and it's a waste of money. Okay, so we're moving on. And the other thing to remember is if you have been under proceedings or reporting to a judge for deportation, or you have a deportation order from the past, you must first deal with that issue before you file your waiver. There are numerous people in the immigration courts today that would qualify for this waiver. As a matter of fact, every week the immigration judges are closing cases administratively, and if you provide information that you have the possibility of getting this waiver and allowing the applicant to apply for the waiver, and then once it's approved, the immigration judge will normally reopen your case and terminate it after the waiver is approved, because the immigration judge knows that you have another avenue, something to get your permanent residence, and it is possible, so he will not keep you under proceedings. Okay? Please remember that the case has to be administratively closed or the waiver will not be processed. All right, so we're moving on, and we see, have you ever been arrested? That's a really important question, because even if you've been arrested for something minor, a petty disorderly offense, disorderly person, a misdemeanor, if you've been in any court at all, or civil court, criminal court, municipal court, you have to obtain your records and your certified dispositions. And you also want to make sure you have in your possession your police reports if they are available. And these are important things that you would take to the immigration lawyer so that he will again see if you are a person that in fact qualifies for this provisional waiver. I have here on the, we're moving on, and I have a checklist that normally this is what you would do if you were going to apply for this application. You would have to pay the visa fee to continue with consular processing, and that would, right now in the United States, you would be paying that electronically through the National Visa Center. It is a $318 fee, and once you get the receipt and you gather all your documents for the application, which are, we give a list a little further on in the presentation, and you gather all of your original certificates, your birth, your marriage, your divorce, you get all those together so that you're going to be ready to pay to file your application. All right, so we're moving on, and we can give you a list of supporting documents, of things that are important to, in fact, file this waiver. You need your passport. It has to be valid. If you have an old passport, it's important to show your old passport. If you happen to still have it, it will show the entries and exits that you've had. Those are all very important to determine whether or not you would qualify. You need the birth certificate of the petitioner, the person filing from you, which would be your spouse or your parents, your marriage certificate, any divorce decrees from previous marriages, either on the petitioner side or the beneficiary side. You would need your birth certificate of your children. You could also bring the birth certificate of your other children, even if they're not pertaining to that relationship, because they could be your stepchildren, they could be on your income tax return, and you have a relationship with them, so that overall will be important to determine whether or not there would be extreme hardship to the petitioner, and the immigration would look at those things as well. You need to take your current income tax returns as well as any income tax returns through the time period of the relationship. And even before the relationship, I would suggest taking all of the income tax returns, because it proves you were in the United States. It proves you were an intending immigrant, that you paid your income tax, and that is always a very important issue with immigration judges and with the Immigration Service. There is one thing to remember about the income tax returns. When you bring them to the immigration lawyer and you bring all this information, certain income tax returns, if they do not show above the poverty guidelines, which are published by the Department of State, they will not be valid for immigration. So if you declare less than $10,000 adjusted gross income on your income tax return, then it seems as if that's impossible. There could be other issues for tax evasion, fraud, and so it's really important to take all of these things and have them reviewed by a professional, an immigration attorney in your area. You would also have to submit your current pay stubs from the company that the petitioner is working. Also, if the beneficiary has any, the applicant, he should submit them as well. Any lease, rent receipts, household bills, those are, which may be past due, those are due now. This shows that you're living in a relationship, that you're contributing to the petitioner's life, and that it would be difficult later on if you were to separate for a long time, if he had to pay all these bills because maybe he couldn't work as many hours, and so it would be a hardship on him. So these are all things that would have to do with the hardship decision that immigration will make. You should take any school report cards of your children, any medical records of all medical conditions of the family. This is a really important item, because I usually start out when I'm interviewing a candidate for the waiver asking, does anyone take any medication? Even if it's something as simple as what you may believe to be cholesterol medication, high blood pressure medication, because it depends on the whole analysis of the family as a whole. If the petitioner is over 40, if he takes medication for anything at all, that is very important, because I would suggest getting a letter from the family doctor or the doctor he goes to show that, yes, he has this condition or she has this condition, and it would be hard if this person had to be separated from the main family member, his spouse. She wouldn't be able to help him, or he wouldn't be able to help her, or it would be a lot of extra stress on this person's life. And so if they already have a medical issue, this can all lead to proving extreme hardship, even though it seems as if it's not that important. As a whole, the immigration will analyze this, and it is important. The next thing would be family photos. Any family photos that you can have showing that, the family unit, that's always important for immigration. Letter of recommendation from jobs are a great source to show that you're trying to fit into America. You want to be part of the income of your family. You also are a good person. Another thing that you may want to submit would also be something that you've done for volunteer work, maybe in schools. if you volunteer in your child's school, even if you're not working. It shows that you really want to be part of the American way of life. And this is important in deciding the analysis of whether or not your case of extreme hardship will be proven or not. The other thing is supporting letters from friends and family. It's very important in a case to prove extreme hardship that you obtain at least 4 to 5 minimum, in my opinion, letters of character references of people who know you, know your family situation, and can say why would it be difficult for the American citizen to be separated from you as an applicant for a long time. What would be the reason it would be so difficult? Why would it be difficult if this American person had to go to another country and leave his job? And how would it be extreme hardship to that applicant? So that's why it's very important for other people who have known you and your relationship to substantiate that through the form of an affidavit, which must be notarized. And it should be people who really know you, not someone who just you asked to do this letter that you think is a great person to do the letter. It should be someone who sees you, who personally observes your relationship at least on a monthly or quarterly basis, so that they can put down in paper that, yes, it would be an extreme hardship and why. And the letters must always have the date they met you, how often they see you, and what type of relationship it is. And usually I would definitely attach a photograph, if you have a photograph of your time spent together with this applicant. That always proves for good evidence for the Immigration Service. So we're moving on now to extreme hardship and what exactly is it for the Immigration Service. You may submit evidence of extreme hardship, and I'm listing them here and showing, you know, how you can prove extreme hardship and what it comes down to. Number one reason would be health. For example, as I spoke about before when we had the list of documents, any ongoing or specialized treatment required for a physical or mental condition, the availability or quality of such treatment in the foreign country. So, for example, if your wife is in El Salvador or if she is in Brazil, how much availability of treatment of this particular service would there be? There's pros and cons in every country, so, you know, we have to research and see. According to the State Department, they publish reports every year. They talk about the medical conditions in those countries, and those are available online at the Department of State website. You go on to the Department of State website and you check and see what are the country conditions of this country. And if they're really bad and you have a person who needs special treatment, you can always allege that and argue that in your application. The anticipated duration of the treatment. Is it chronic versus acute or long versus short term? So, for example, if you have someone that is going through a short treatment and it's available in the United States but not somewhere else, that would be good. If it's a long-term treatment and, you know, you have to consider your possible employment in another country. If you're over 50 or over 45 and you work construction, you may not be able to get a job in another country, so you, as the American citizen, will have extreme hardship if you're forced to go to be with your wife. Or if your wife has to go and then you have no one to take care of your children, and basically that's what she does, that could be extreme hardship if you work it up together with all of the other information that we have here. Okay, second consideration would be financial considerations. For example, future employability. I went into that a little bit in the health aspect because they're all connected and related when you make your argument for extreme hardship. But if that country has a high unemployment rate, then it would be difficult for anyone to find employment there while they went to wait for their waiver abroad. If they were going to Portugal and the unemployment rate is very high, it would be very difficult for them to support their family in Portugal if they don't have a job there and they have one here. So the loss due to the sale of a home or business is another aspect, or termination of a professional practice. If you have a home here and you pay a mortgage, or you run your own business, it would be very difficult to go to another country and start up your business again. And if your wife had to go and you have children, or even if your wife helps in your business or she helps in your home, that would be a huge detriment to you, because you could not just leave your business and go to another country. And if you stayed here and your wife left or your husband left, it could be either or, it would be really tough. Or let's say you have a family business. Your U.S. citizen parents have a family business and you participate in the business. So if you left, it would be very difficult for them to find someone that they trust to run the business, and that could also be extreme hardship. Therefore, if you went to another location, there would be decline in your standard of living, or even if you stayed in the United States, you would not have your other related person to help you. So in that way, your standard of living would go down and you would be suffering extreme hardship. Extreme hardship is not just one thing. Unless you have a serious medical condition, then that will be able to allow you to prove the extreme hardship a little more easily. But most people that I've seen, my clients, they don't usually have one specific aspect of extreme hardship. They have the health condition maybe a little bit, financial considerations a little bit, and they have other things, and this all put together has to be argued that as a whole it is extreme hardship. The immigration has guidelines that they look at different things, these things we're mentioning here, and they weigh the bad and the good, and they see how bad would it be? Is it really extreme hardship? And another thing, if we continue under the financial considerations, we see that there is a cost of extraordinary needs, such as special education or training for children with special needs. You know, if you have a child and he has an IEP, which is an individualized education plan, it means that he is in a school where he has special needs and he's going to need extra help. Is that available in the country he'll go to at home? Because if mom or dad leaves, they may be probably taking the young children, because dad wouldn't be able to stay here and take care of the children if he's running a business or working construction. It would be really tough for him. So that's all very important to argue. You don't always have to have, you know, a child with special needs in order to win extreme hardship, but it definitely is a plus. Another thing would be the cost of care for family members, elderly or sick parents. So if you are filing your waiver on the fact that you have citizen parents and you take care of them, you help pay for things, or you take them to the doctor, or you're there for them. If you were to have to wait for a hardship waiver in your country, it could be the minimum probably 5 months, 6 months. That's ideal circumstances. So there would be extreme hardship to your elderly parents in that case. You have to document it. You can't just say, my mom and dad are sick and they're old, I need to be there. I mean, that's not going to cut it in an affidavit. That's not enough. You have to document these cases really well in order to be successful. So we're moving on, and let's see what we have. Education is another aspect for extreme hardship. If you have the loss of opportunity of higher education, or lower quality or limited scope of education options, a disruption of current program, like you're presently in school, you're studying, you're going for your master's, and you wouldn't be able to do it if your other half or your child were helping you, or if you are going to be breaking up your education and having to go to another spot, another country, and then your parents would have to help you again when you came back. If you wouldn't be able to study as easily because you're going to have to work harder because you won't make as much money in the other country. Or your American citizen spouse here as well, they are pursuing a higher education and you're helping cover all the bills in the home. So it would be hardship to them. They would have to stop their education, their master's. If they're going to dental school, they're going to be a doctor, or they're going on to be an engineer. This is all extreme hardship, and it has to be shown, it has to be documented. Amongst education, we have the requirement to be educated in a foreign language or culture with ensuing loss of time or grade. In other words, if you don't speak the language where you would have to go for a long amount of time that well, you would have to be trained in, and you would have to learn the language. So this is also hard for you. If you're an adult, it's harder to learn a language if you have to go to another place. So that would be hardship. There also may not be the availability of special requirements such as training or internships in specific fields. All of this put together will create a package which you must convince immigration that it is extreme hardship. It's not just we're going to be separated and that's not good because we're married, or we're going to be separated and mom and dad are old and we need to take them to the doctor. There are many other scenarios. I've just given you two. So I cannot stress the fact that it's very important for you to see an immigration attorney in your area to know that is it worth it for you to file this application and what needs to be put into this application so that it will be successful. Item 4, as we're moving on, are personal considerations. For example, there's close relatives in the United States and country of birth or citizenship, and there would be separation from your spouse, your children, and the ages of the parties involved. I mean, if they're elderly and you're going to be separated a long time from elderly parents, they don't have that much of a lifespan. So that can certainly be argued. Also, if you have many close relatives, you have uncles, aunts, cousins, brothers, sisters, and they're all in the United States, you will be missing out on your opportunity to spend time, and as a family, an extended family, you'll be missing out on time spent with family, and that can get emotional. It can cause you hardship. I mean, if you have to go to a whole new place for a couple of years, it is not easy. Not only will that, prejudice usually your job opportunities, it'll prejudice your educational opportunities, it'll prejudice your personal considerations of having emotional trauma or depression. So it's very important to allege the length of residence and community ties in the United States, that you've been here a long time. If you have that, your whole life is here, and also your applicant has been here maybe for a long time. And so it would be very difficult to go back and be separated for a certain amount of time. There's always then, as we move on to number 5, special factors. Example are the cultural, language, religious, and ethnic obstacles, the fears of persecution, physical harm or injury, social ostracism or stigma, access or lack of access to social institutions or structures, and the official or unofficial, whether they be official or unofficial, for support, guidance, or protection. We are fortunate in the United States that we are one of the countries that allows someone to practice the religion that they would like to practice. We will prosecute people who do not allow freedom of religion to our citizens. And other countries that is not available as much or not available at all. So if you're going to be separated to a country that doesn't allow for you to practice your religion, or if you are politically active, they may not, allow you to practice your beliefs, and you may be put in jail, or you may be harmed, or as an American citizen, you will not be able to have your liberties that you do have in the United States every day. So this is a really important thing to bring out, especially if you have a candidate or a petitioner who is active in a political organization or is active in their religious organization. And if you were going to go home, that would not be available for your, if you were going home for your beneficiary, your applicant, that would not be available to the country they're going to. So that would be a special factor to allege and to request for your provisional waiver. All right, so we're moving on here, and I have a list which you can certainly look at it to give you an idea of what you would have to submit if you were filing this waiver. Number one are affidavits from qualifying relatives or other individuals with personal knowledge or claimed hardships. I talked about it a little bit before. I would recommend minimum 4 to 5. Usually I submit 10 to 12. Every situation is different. They must be notarized. They must be able to really give in-depth analysis as to why it would be difficult for the separation to occur. So therefore, you know that it has to be someone who really knows the applicant and the U.S. citizen petitioner. When you have expert opinions, that's number 2. When you have a medical situation, you must submit opinions of that professional, whether it be a medical doctor, a psychologist, a therapist, someone who is familiar with what you're going through that can substantiate extreme hardship. You can certainly allege on your own that you're depressed if you're going to go abroad and you can't be separated because you love one another or your family situation would not be good. But if you happen to have, if you've been in therapy or you've taken antidepressants, or if your situation has some special consideration medically, you need to support that with an expert opinion. And that's really important, okay? And don't be afraid to ask your doctor, even if you haven't been there in a while. And, I mean, because doctors usually are very cooperative. They don't have to write a long opinion or a long statement. They can just say that you are their patient, that you take XYZ medication, and because of your diagnosis, and they would state what the diagnosis is. And then that can always be tied into the argument that it's not as readily available. It would cost a lot of money. If you're an American citizen and you don't have health insurance in the other country, it's going to cost you a lot of money to get this medication. You're not supposed to mail medication to other countries. It's illegal. So, you know, this all has to do with proving extreme hardship. Number 3, evidence of employment or business ties, such as payroll records or tax statements. So here, this is critical to submit all of your payroll tax records, your tax statements, to show that you are an American who complies with the law. You file all of your income taxes. And please remember that they cannot be income taxes that don't really prove that you're supporting someone or you're supporting the children. I mean, if you have 5 children, you can't be claiming you make $15,000 on your adjusted gross income, because it's just not going to work. And if you have filed bad income tax and maybe the tax preparer was not as well versed in what you would need for immigration, you can go back to your tax preparer. You can tell them, I need to declare more income because I didn't know I could declare the cash. But, you know, you need to do it. You can do it now for the past. You will be paying penalties and interest, but if you really want to obtain your permanent residence, there's no other way around it. You have to do it. Okay, so I'm moving on to number 4. Usually with the provisional waivers, I submit evidence of monthly expenditures, such as the mortgage, the rent, the bills, and invoices. And This would be done in the format of a chart. It doesn't have to be a specific chart. It could be an Excel spreadsheet. It could be, you have on one side what you're earning, and then on the other side you have all of your expenses to show that the income that you receive pays for your family expenses or helps with your extended family because you live together. And it's very important because this way you can show in black and white that, yes, it would really be tough if there was a separation. I would submit all of these bills and invoices and all of these expenses to show that, yes, your payroll or your amount you're claiming on your tax return does cover all of these expenses in the United States. And, if you were going to go to another country, that would be tough. All right, number 5, other financial records supporting any claimed financial hardships. If you have a lot of debt and you're paying a debt for some reason, your credit cards or something of that nature, and you have to pay this. If you went somewhere else or your wife left, it would be hard. You wouldn't be able to pay it. Who knows? You'd probably have to file for bankruptcy. Or if you couldn't afford to if your wife has been working and claiming income as well, that's usually the ideal situation. If the applicant has been in the United States for a number of years, then usually I always say that that applicant usually is declaring some money on the tax return. Usually if you're undocumented, you're declaring cash for cleaning, for domestic services, for taking care of children, for running your own business. You definitely should be declaring some income on the tax return with your spouse or on your own to show that it would be difficult to pay all these bills if you had to leave. And so that is something that always is important, especially with these waivers. Most of the waivers I've done, I've been successful, and I prove that, if the wife was showing income or the husband and they leave, and the kids are young, maybe every scenario is different, but if you have young children, it could be that the husband would have to get help from the government. So the government would have to pay for your children to get extra food stamps because you had to leave, because when you were here, you were helping, you were supporting the family, and you were claiming this on your tax return. You can't say you help financially. It's very important to remember, it's very hard to say you help financially if you're not claiming the money on the tax return. So please remember that. And the government always likes to hear that you are helping out so that the family unit is being supported and they're not going to receive any extra entitlements from the government. One of the criteria to become a permanent resident is that you are not going to become a public charge. If you're a public charge, you're inadmissible, which means you will be denied your visa. So it's very important to show that your tax returns reflect the current guidelines and are above the guidelines of the poverty guidelines of what the Department of State puts out. Because if not, then you could be inadmissible not only for being here illegally, but for being a public charge. Okay, it gets a little complicated. That's why it's important that you must see an immigration attorney. It's important to note that someone who is an immigration attorney usually cannot be specialized in everything, every type of law. Look for someone who is specialized in immigration, could do a couple other fields of law, but does not do everything in the book, because it's impossible to know immigration law and be able to keep up on all of the updates. They're being constantly updated every day as we speak. Today in Congress even, I mean, every day on the Hill in Washington, they're discussing comprehensive immigration reform, and a lot of these new reforms are affected by our current system today. So the only thing I can possibly tell you is please see an immigration attorney in your area. It is really important. And even though it may cost you a little bit of money, if you do it on your own, sometimes it's going to cost you more money later if you get a denial or if you claim something that later on cannot be fixed. And that happens. I mean, if you put something down on an immigration form and later on you say, oh, I didn't mean to say that, it's not going to cut it with immigration. Then you have other issues of fraud and misrepresentation. You don't want to deal with that. So it's really important to see an immigration attorney. I'm moving on now to number 6, the medical documentation and or evaluations by medical professionals supporting any claimed medical hardships. I talked about it before, and it's very important for you to definitely include this in your provisional waiver packet. Okay, we're going number 7, records of membership in community organizations, volunteer, confirmation, and evidence of cultural affiliations. Okay, if you belong to a community organization and you are a petitioner, and if your other family member leaves, you may not be able to do this anymore because you have no time because the family member was helping you. If, for example, you go to another place, they may not have these community organizations. And it's very important as a volunteer to get a letter from where you volunteer, because the immigration and the government always like when you volunteer, because you want to be part of a society. You want to become part of American society where we believe volunteerism is very important. We need to give back to a country that gives to us, because there's many other countries throughout the world that do not give anything to their community. So, you know, in order to become part of America, to be a future citizen, you have to show this. So if you volunteer at your kid's school, or if you volunteer at the church, you know, submit something showing that you did a cancer day, or you did a multiple sclerosis benefit, or you helped the poor, you gave out food, anything at all. All of this is important to the immigration and to the government, and it's really important to submit. So another thing would be evidence of your cultural affiliations. If you help people of your ethnicity and you are helping other people, whatever you do, it's really important. It's a plus for a waiver. A lot of people think, oh, it's not that important. I don't do it that often. I do it once a year. I don't really go to church, but sometimes I do. I help a person, or I've done X, Y, Z at some other organization. It's all important, very important. So I think as we're moving on now, you can locate the form and the information. You can read the instructions on the website, uscis.gov, and you can also get more specific information about the whole process of this specific waiver under the second website, travel.state.gov, Visa Immigrants NVC 583, the website that is referenced here. And at this time, we would like to open the discussion to someone who may have a question. So whoever has a question can certainly submit that, and I will try to answer your question.
Thank you, Cynthia. We do have a few questions that have come through. First question is, the listener noticed that some of the documentation required would be income tax statements or pay stubs, things like that. So does that mean that the applicant must already have a green card or some other type of status as an immigrant, or does this apply to anybody?
Okay. The applicant in this specific waiver is a person who needs to obtain permanent residence. So they may have some sort of status, but usually 95% of the time they are an undocumented immigrant, so they will not have a green card. They may have some other status, but it is not a permanent resident status. The objectivity of filing this waiver is to obtain permanent residence. So if you are married to a U.S. citizen and you cross the border, let's say, okay, and the question going back to the tax return, it all depends how many years you've been in the United States. There are people who've been here 10 years. There are people who've been here 5 years. There are people who've been here 3 years. So the Immigration Service will overlook the fact that if you've been here for 1 year, maybe 2 years, and you didn't earn any money or you didn't earn enough money to file tax return, let's say under $10,000. Usually there's a cutoff of you do not have to file a tax return according to the IRS if you earn less than, I believe it's $9,800 or let's just say $10,000. So it would not be a good idea to file tax returns if you earn less than that amount of money and you've only been here a short time. But if you're a person who's been here a couple of years, you know, we're talking after your 3rd year, your 4th year, especially 8 years, 10 years, then the government is never going to believe that you weren't working. So you don't have a Social Security usually. You may from another type of process if you're in another status. But if you don't have a Social Security and you file your tax return, most tax preparers, I would stress, please go to accountants, not people who do not, who do other things as well, and may not be as well versed in a tax ID number, which is what the government gives you. It has the same digits as a Social Security, has the same number of digits. It starts with a 9, and the IRS will take your money. You go to a tax preparer, and let's say you earn cash for a couple of years. You would have to go to a tax preparer, file your taxes based on cash, and then the IRS will send you this tax ID number. And that's what mostly undocumented applicants would do. Do you need a tax return for all the years? Not necessarily. Every situation has to be looked at. I mean, we need to look and see, how are you supporting yourself? Were you living with a family member and they put you down on the tax return? Were you living on your own before you met your husband or your spouse, who's the American citizen, and they didn't have, when you got together, maybe they put you on the tax return, but before you got together with him, if you're not married for a long amount of years and you were here a lot of years, you know, immigration is going to look at that. They're going to say, well, how did you support yourself? So whether or not you need income tax for all those years or any of the years has to be analyzed on the number of years you've been here, and usually you are undocumented, so the people applying for this waiver would like to obtain permanent residence, so usually they're undocumented or in another status. I hope that answers your question.
Yep, that was very thorough. Thank you. Our next question asks, how long does this process usually take, and if you are denied, are you able to reapply?
Okay, that's a great question, by the way. Okay, usually if you go back and you see the information, we have to have an approved visa petition to start this waiver. So an approved visa petition, it depends on if you're a U.S. spouse or if you're a U.S. parent. If you are a U.S. spouse, that is an immediate relative. So to the immigration, that means you can come pretty much right away. You don't have to wait for a visa according to the quota. However, there is a processing time. So today, if I were to file the I-130 application, which is the first step before you can file the waiver, it is taking minimum, according to the website, about 6 months to 8 months. You may be lucky, you may get an I-130 approved in 4 months, but let's just say it takes 6 months. After you have the approval of the visa petition, and you're a person that has that already, you apply for this waiver. Since the waiver is new, we only have been able to file since March 4th, we are not really sure how long it will take. But in the past, the waiver took minimum about 3 months. However, I was at a conference last week, an immigration conference, where the immigration confirmed that based on their statistics, they had received almost 5,000 of these 601A waivers, but they had only granted 15. But that tells me that people who filed right on March 4th already have an approval of the 601 waiver, and we're in June, mid-June, so that would be March, April, May, about 3 months again. So let's just say, perfect scenario, you are approvable and you obtain the waiver in 3 months. So you have 9 months, counting the approval, if you didn't have the approval. But if you already had the approval, we have 3 months. But after those 3 months, you have to file consular processing. It would be another 3 months. So I would say 6 to 8 months on the average total, if you have your approved visa petition. And if you do not, you have to add another minimum 6 months to that. Now, as far as, once your provisional waiver is approved, you then continue consular processing, you file some other forms, and then they set a date for you to go to your consulate. Let's say you're going to Rio de Janeiro, Brazil. So you have a date set. August 15 is your day. It's very important to review with your attorney before you go what will be discussed, what questions they will ask, so that you go prepared and you're not, in trouble when you get to the consul. Because, when you go to another country to get a visa, everything's been approved here, but there always is a slight possibility that if you didn't tell your lawyer everything, or if you have some other issue that may make you inadmissible, that you get denied when you go. So that's why I really have to stress that you must see an immigration professional before you go. It's really important. I mean, if you have a clean-cut case, what you consider clean-cut may not be clean-cut to the immigration. So, but if you have a perfect scenario case, it should technically take about 8 months door-to-door from, 6 to 8 months from when you file this waiver. I hope that answers your question. Oh, if you're denied. If you're denied, you can file again, just like other immigration forms. You're not prohibited. But do remember that whatever you file becomes a record for immigration. And it is very difficult to overcome a bad answer. And all of your, when you answer a form on an immigration form, when you answer a question on an immigration form, you have to think, what is the result of this answer? And a lot of people just go and fill out their own forms, and they're not aware of what will be the consequence of this answer. And that's bad, because if you put something down on a form, you may not be able to overcome it. Yes, you can file it again if you're denied. There could have to be probably changed circumstances. I wouldn't file, you should go to a lawyer and see, is it possible, will you be successful, or is it even worth it? That would be my advice. Okay?
Great, and we have time for one more question. This should be pretty simple. Is there any age restriction to this process? Do you have to be of a certain age, or is there a maximum age that would prevent you from applying?
Well, in order to file if you're a husband-spouse situation, then you have to be the age to marry in your state. So you can be under 21. If your state allows you to marry, then that wouldn't be a problem. If you are a son or daughter of a U.S. parent and you have the approved visa petition, you can be any age. It doesn't matter, because anyone who is a parent who is a U.S. citizen can call married children, can call single children. It doesn't matter. There is something to remember, that if you're, I guess if you were disabled or you have mental issues, other waivers would be needed. Or if you're really, I can't imagine you'd be really, if you're really elderly, that's not usually the case. There's certain scenarios where the immigration, may make you provide health insurance or the ability to pay it. But that's not the norm. because usually in this scenario for the waiver, you wouldn't have many really elderly people applying.
Okay, that concludes our webinar for this afternoon. If you do have any other questions, as we mentioned, please feel free to send them to palcus@palcus.org, and we will answer them directly. All the webinars are posted on our website and our YouTube channel for viewing at any time. The links are here. So we strongly encourage you to go back and watch the webinars again, share them with your family and friends, anyone who was not able to attend today. They are there as a resource to the community to be shared. And here's a list of some of the past webinars that we've conducted, and our future scheduled webinars. One will be on the Portuguese Heritage Publications of California and some of the projects that they're working on. So thank you very much for attending. Thank you, Cynthia. And
thank you, Angela.
Thank you very much. All right. Goodbye, everybody.
Okay. All right. Bye-bye.